Welcome, everyone. My name is Jeff Zaino. I'm from the American Arbitration Association based here in New York. Thank you for those that are in the virtual audience. I see we have a lot of people in the virtual audience. And for those that brave the rainy weather in New York City for being here today, thank you. And also, I want to thank Peter Phillips and New York Law School for this collaboration that we've had now for many years, and we greatly appreciate collaborating with you. I'm proud to say this is the 8th time we've done this program. Okay, the Stephen C. Bennett annual program, Cutting Edge Issues in Commercial Arbitration. Before we get the program underway, since the passing of our friend Steve Bennett in December of 2019, who was an original member of this cast, okay, and who was a great friend of the community, the ADR community, and since 2020, we named this program after Stephen Bennett. He was on the panel again for 3 years, this panel. We always do a brief brief tribute and a moment of silence. Again, he was a wonderful friend of all of us in this community. And Jen Lupo, a member of the new panel, he's a member, our new cast member, has agreed to give a tribute to Steve, and then we'll do a moment of silence. So Jen, I'll turn it over to you.
Thank you, Jeff. For those of you who don't know Steve, I will say this. He was my mentor. He was my friend. He was kind, generous, and he was funny. And this is the thing that most people don't know about him. He was a comedian, literally, and he used to perform under the name Steve Carl. And the last time I saw my friend was in the summer of 2019, before I moved to Europe, at Caroline's. He was one of the most generous people I know. And I would hope that all of you today be a little generous to someone in Steve's memory. And at this point, if we could have a moment of silence.
Great, thank you. Thank you, Jen. That was beautiful. Okay. Oh, actually, I want to ask a quick question to the panelists. Who was on the original panel in 2017? Raise your hand. Steve, I think you were too, weren't you?
I don't remember.
Okay, so three of you. Okay. Now, I want to introduce our panelists. They're all AAA ICDR panelists, and they're all friends of mine and colleagues. And starting to my immediate right, we have David C. Singer, SingerADR Neutral Services. We have Richard Mattiaccio, Chartered Arbitrator and AAA Arbitrator, ICDR Arbitrator. Jennifer Lupo, Lupo Law, Arbitration and Mediation. Rich Silberberg of Silberberg Dispute Resolution. Dana MacGrath, MacGrath Arbitration. And Stephen Skulnik, Thomson Reuters, and also AAA ICDR Arbitrator. Okay, we have 3 topics tonight, 3 great cutting-edge topics, as we always do. Please feel free to ask questions after each topic. We're not going to wait until the end. So we have 3 topics. The topics are, and Dana and Steve will cover the first one, are arbitrator and institutional immunity. That's the first topic. The second topic is Richard and David will talk about a clash of duties, the arbitrator's obligation as arbitrator to maintain the confidentiality of the proceedings and as attorney to report attorney misconduct. And then the final, they'll close it out, Rich and Jen, tricky issues involving pre-award interest, attorney's fees, in-camera reviews, and non-party subpoenas. And this is a CLE program, so after each segment, please remind me to give you a letter, okay? And I'll remember to do that. Okay, so we will start off. I'll turn it over to Dana and Steve to talk about arbitrator and institutional immunity. Dana and Steve, take it away, please.
Okay, thanks, Jeff. So these are 2 related doctrines. They're not exactly the same. I mean, arbitrators and institutions do different things. So the contours of when one can sue either one are slightly different, but there's a lot of overlap. And so how we've decided to divide this up is Dana's going to start with talking about
I know you're on the phone. When I came back with my sandwich, I didn't know you.
Institutions and my institutions. I'm talking about AAA, ICDR, ICC, etc. Okay,
straighten it out.
Yes. Good evening, everyone, both here and live. And I want to just thank
I know that
Phillips and New York Law School, and Jeff Zaino, and the AAA, and all my fellow panelists for this wonderful reunion, which I think is the second since we emerged back into hybrid programs from the pandemic. So it's a pleasure to be here.
Fine. So then that was up to Unum to provide it to them.
Side of arbitrator immunity, and as Steve mentioned, he will be talking about the immunity of arbitral institutions, although they are sort of intertwined. It's with respect to the immunity of arbitrators in their service as an arbitrator. It's a common law doctrine. I mean, this isn't really codified anywhere, although the restatement does, sort of, describe it, and that's a, informal way of codification, so it's not codified. It's a common law doctrine that went through the courts in a very kind of bumpy way, but always came out, for the most part, in favor of recognizing immunity of the arbitrators and defining the contours of how that, quote, absolute immunity extends. And it's inspired by the immunity that judges are given in the courtroom, so that they are not restrained from doing their duty as judge for fear of prosecution. And so in that respect, it's sort of called like the role of an arbitrator, sort of a quasi-judicial capacity. And in that respect, the doctrine was extended to arbitrators who are deciding cases just in a private setting. The key aspect of the immunity is that the arbitrator is acting in their role as arbitrator, and any of the issues that arise in a case should not touch the role of the arbitrator. So that's what the immunity extends to the extent that the arbitrator has done something in his or her role as an arbitrator, whether it's dealing with document disputes or schedule or witness appearance or, whatever could come up in the lifespan of an arbitration and the arbitrator's role in it. Those kinds of acts are what the immunity applies to. And in that respect, it's called absolute immunity for your performance of your role as arbitrator. In the judicial context, this comes up in two ways. If a party who arguably is less informed about the doctrine of arbitrator immunity tries to bring a suit, sometimes they bring it and the court dismisses the case based on the arbitrator's, quote, immunity from suit. And in other cases, they get to the same result by calling it, a lack of subject matter jurisdiction. So, but the analysis is really, is the arbitrator acting in his or her arbitrator role? And if so, then there's immunity or a lack of subject matter jurisdiction. And like judges, the purpose of this doctrine is to encourage arbitrators to render fair and independent decisions, and to be able to, sort of a derivative of that, is to be able to structure the proceedings in a way that comports with the arbitration clause and is time efficient and affords the parties an opportunity to be heard. So all of the things you think of procedurally with respect to what arbitrators do, dealing with the procedural schedule, document disputes, ensuring that each side is heard on issues that are either anticipated at the outset of the case or which come up during the lifespan of the case, whether substantive or procedural, all of those kinds of issues that arbitrators deal with, and then running the hearing, events that take place at the hearing, deliberations and the award. All of that is part of what many of you, if not all in the room, are familiar with as the role or activities in which the arbitrator has a role in his or her capacity as arbitrator. That what is not immune or would fall outside of this arbitral immunity would be something that really has nothing to do with the arbitrator acting in his or her role as an arbitrator. So, one example was, some sort of personal altercation that took place between an arbitrator and counsel that had nothing to do with the arbitration, and there was a tort claim brought. That is unrelated to the arbitrator acting as an arbitrator. If there was some sort of allegation of criminal misconduct, a bribe of some type, that would not be part of, that would be immune, so to speak, under the arbitral immunity doctrine. but there would be judicial relief. There would be an avenue for judicial relief. You could seek criminal prosecution for criminal wrongdoing. So when we say this immunity is absolute, it doesn't mean that in egregious situations, when an arbitrator outside of his or her role as arbitrator does something that's not good, that there is no judicial avenue for relief. So sometimes people seem concerned that the doctrine is too broad, but if you really see it in the context of its purpose to allow a fair, efficient, and a good proceeding in arbitration, then I think that it's so well received by the arbitration community that we see it actually incorporated into the rules of many arbitral institutions. So that's not codification, but rules have incorporated this doctrine, or basically said, as a matter of contract, so to speak, by adopting these rules, you sort of reiterate your acknowledgement that arbitrators have immunity in their role as arbitrator. So with that.
Great. I will take it over regarding the institutions, and there the courts make a distinction between the administering institution playing an adjudicative role or a commercial role. And so for example, a removal of an arbitrator or failure to remove an arbitrator, that's adjudicative, refusing to disqualify an arbitrator. Wrongfully taking jurisdiction, let's say the clause doesn't say AAA ICDR, but ICDR takes it anyway, they're immune. Even defective notices of hearings and irregularities in the selection of the arbitrators, again, full immunity. There was a case start from 2000 against the American Arbitration Association in the Seventh Circuit that had some dicta that suggested that the institutions wouldn't be immune for pure commercial activities such as overcharging or refusing to return deposits, that kind of thing. And that makes sense. And this all came to the fore in 2022 in a case that I recommend that you all read if you want to know everything there is to know about institutional immunity. It's called Marcia Shore versus American Arbitration Association, 2022 Westlaw 179-65413. And what happened there, Mrs. Shore entered into a partnership or through an LLC with a certain Sebastian Doggart to develop real estate in Cuba. What could possibly go wrong, right? And they had a dispute, and Mr. Doggart was trying to get rid of his LLC shares, and Mrs. Shore, represented by her son, Mr. Shore, who was a lawyer, brought an arbitration seeking interim remedies. So there was an emergency arbitrator. There was an injunction issued. There was something but Mr. Doggart, he seems to have been a problem. He didn't pay any of the fees that he was invoiced. He apparently was abusive to the arbitrators and the staff and to opposing counsel, making anti-Semitic slurs, et cetera. A fairly bad actor. Mr. Shore wanted to invoke, or Mrs. Shore wanted to invoke this clause called the inquest clause that they had in their arbitration agreement. And that clause, which he claims he got from the AAA ICDR clause builder, said if one party doesn't pay its invoices and the other party has to cover those costs, then the non-paying party can't even cross-examine witnesses or put in its own evidence. Obviously, under the rules, the counterclaim goes out, but they weren't even allowed to defend. And the AAA and the AAA arbitrator said that's inconsistent with the rules, and they wouldn't allow for an inquest. So he was all upset about that. He was complaining. Eventually, now this all came up on a motion to dismiss. So Judge Engelmeyer took the facts pleaded as true for the purposes of the motion, but apparently the AAA, according to Mrs. Shore, just threw up their hands and said, we're not administering this case anymore. Mr. Doggart is too abusive, and we're not giving you back your money. And so Mrs. Shore sued the AAA and Mr. Doggart, and the court made that distinction between arbitral immunity, which is adjudicative, and commercial activity, such as not returning the money when you won't finish the case. And so on the claim of interpreting the inquest clause, and whether it was consistent with the rules or not, both the arbitrator, who wasn't sued, but the arbitrator and the institution would be immune, because that is when an institution interprets its rules, that is an adjudicative function. The rest of the counts dealing with having paid 40 some odd $1,000 in fees and not getting any decision, the court said that was commercial and there was no immunity. However, as Dana mentioned, the procedural rules of most institutions have a contract where the parties who are participating agree not to sue the institution. And here it was an ICDR case, but it was under the commercial rules. 52D says parties to an arbitration under these rules shall be deemed to have consented that neither the AAA nor any arbitrator shall be liable to any party in any action for damages or injunctive relief for any act or omission in connection with any arbitration under these rules. And Judge Engelmeyer applied that clause as it's written and dismissed the balance of the case. We'll never know what really happened because it was based on accepting the allegations as true. I can't imagine that AAA would punish somebody who was behaving properly and reward somebody who was behaving improperly. I'm sure Jeff probably knows the backstory, but he probably can't say.
Yeah.
And I actually know who the arbitrators are, and they can't say. But this case will really does cover the contour between adjudicative and commercial, and then separately the enforcement of the rule providing for no liability.
Great. Okay, thank you very much. Do we have any? Oh, well, first of all, any comments from our panelists? Welcome. Any comments or questions from our audience?
I guess I would just say that note that this approach is not unique to the United States,
Yep.
Particularly with respect to arbitrator immunity. But there are countries that are leading arbitration centers where arbitrators face personal liability for simple negligence in the performance of duties as an arbitrator. I can't give you a list. I have one in mind, but for all I know, the law has changed since then. This is a really evolving area. But I do know that I crossed that country off the list in terms of where I would serve as an arbitrator.
Yeah, if I may, to just comment to that, you all got an email, I think, yesterday with the CLE materials. One of them is a practice note by Practical Law, where I work, called Arbitrator Immunity, Institutional Liability in International Arbitration, and it does survey many, many jurisdictions.
Right.
So if you're interested in this internationally, and these resources are kept up to date. So I printed that off 2 days ago. It's up to date. If you're a subscriber, you can keep checking to see when it gets updated.
So that everyone who's in this course will know which countries to cross.
Well, I
off
was
their
going to
list.
make a sell for New York as the seat of arbitration, because I know that there was a case in New York where arbitral immunity was asserted, and it was very clear that this was sort of bordering on Rule 11, and there was sanctions imposed on a party that knowingly, once there was a conference and it became very clear that this was settled law, was nonetheless, I think, influenced by counsel. You went forward with a case, and you could be sanctioned for bringing a case against an arbitral institution or an arbitrator that's where the immunity is so clear, the law is so clear, and in New York, it is very clear. So New York's better than the country you did not name.
Mm-hmm.
We have a question in the audience.
Oh, hi. Richard, what you said that simple negligence was perhaps not immune under the laws or approaches of some countries. Give me some examples, if you could, of simple negligence by an arbitrator that would fit within that bucket.
Oh,
It's something more than getting it wrong, or is it?
no, it generally, I think, has to do with the conduct of the hearing, not hearing witnesses, not allowing people to pursue certain theories. But it could also be non-responsiveness. You would never see this in a AAA arbitration, but there are places around the world where arbitrators become unresponsive and simply don't perform their duties. May take 3 or 4 or 5 years to do a case. There are usually egregious circumstances.
Michael? You need the microphone, just wait 1 second. Oh, I just want to tell the virtual audience, I can see in the monitor on the podium, if you ask a question, I can read it off, so please note that.
So the question is, are there any cases that you know of where the wrong by the arbitrator has been a failure to disclose that led to their being appointed in a circumstance where they might well have never been appointed if they had made adequate disclosure?
There are cases, yeah.
Yeah, there are cases, and a failure to disclose is not a ground to sue an arbitrator. They're immune. I'm sure there are codes of conduct and all sorts of other things that could be implicated, but when it comes to the doctrine of arbitral immunity, it does apply in that context.
Your remedy is to seek to set the award aside. And that's your remedy. And then the arbitrator gets a bad reputation if it does things like that. But you can't be sued for damages.
Yeah.
Okay.
And there are New York State court cases that deal with that specific issue, and where sanctions are awarded against the plaintiff.
Okay. Before we move on to our next topic, I have a quick question for the group. I just returned from San Diego from the ABA-DR section, and a lot of people were asking me, I was on a panel, and then a lot of arbitrators being asked the same thing about the virtual world and how much you're going into the virtual world, you're staying, you're doing a lot of in-person now. And I'll start with Steve all the way at the end. What percentage are you doing virtual and in-person right now?
So after people got inoculated in 21 and 22, it switched from all virtual to all in person. I have one case now that it's a 2-day hearing. Counsel is from Brazil, doesn't really ask that we can do it virtually because of difficulty in traveling. But every other case I have, even parties from the Middle East, parties from all over, they fly into New York or wherever the seat is, and we hold it. Now, hybrid has become a real thing.
Yeah.
There are always going to be some witnesses that are short, and not of stature, but short in terms of how much testimony they're giving. And so, you say, look, it's only going to be a half an hour to talk about a particular meeting. Can we do that witness virtually? Everyone agrees.
Sure. Dana, what's going on with you? In-person, virtual?
That's been my same experience, is that most of the hearings are in person, but there's often a hybrid component, a witness that testifies. I've never had a situation where an arbitrator was remote, but I've heard of that having taken place. Sometimes when someone falls ill and they don't know what they have, but they want to keep people safe. But I've also noticed that while hearings are in person, a lot of the pre-hearing activity amongst the tribunal takes place through video conference.
Sure.
Much more than before pandemic when we use conference calls or would meet or whatever.
Which method do you like better, in person or virtual? It doesn't matter.
For tribunal meetings, I mean, I always love to see my colleagues, but I think virtual is far more efficient. And so you can hop on a Zoom and resolve an issue and get back to the parties and move the case along. So I'm a big fan of Zoom.
Rich?
Yeah, I would say that it's about 50-50.
Oh.
And I have a number of cases where the parties are in disparate geographies and got, one side is in Florida, one side in California, I'm in New York. And I leave it up to the parties. I say, if you want to do it in person, that's fine. If you don't want to do it in person, I'm also fine.
Yep.
They ask me whether I think qualitatively it'll be a different hearing. I usually say no, because I think that video conference hearings have come a long way.
Yeah.
But to Dana's point, I think there's a lot more flexibility. It's rare for me to have a hearing where there isn't a hybrid component, a witness testifying from some remote jurisdiction. And today, about an hour ago, we just put in place in one of my cases a protocol whereby one arbitrator will be remote because he's going to be on vacation in Martha's Vineyard and did not want to come into New York for the 2 days that he's going to be there. So we are having him appear remotely on consent of both parties. And it just shows the efficiency and the flexibility that you can achieve with that device.
Thank you. Jen?
So I do only domestic arbitration, and I have a question. I would wonder if on the international, you're seeing more in person than on domestic. Because what I'm finding is I'm getting a lot of pushback for people wanting to come into the room because now they can utilize Zoom as opposed to meeting face-to-face for 2 days or a day, even if they're in New York. So that's one issue. I have been the remote arbitrator on an arbitration 2 years ago. I was the remote arbitrator because I had to teach a class, and I was not going to be able to be in both places within the 6 hours. So I was the remote arbitrator. I did not see any difference in terms of my performance. And I had been in person and remote, so I could speak to that. But I would say that in domestic arbitrations, I'm finding people would like to stay remote, and that's good and bad.
Sure. And what about mediation? Do you see more?
So, right, I do a lot of mediation, and in that, I would say I am probably about 75% in person and 25% remote. That's the opposite.
Yeah, that's the opposite of what I'm hearing.
And people love their remote mediation, but certain cases, certain types of matters really do lend to being in person. And once you speak to the folks about why they should be considering being in person versus being remote, you'll get more buy-in. But if you don't have that conversation, I think you would see that 90% of the cases stay remote.
We're seeing at the AAA ICDR in Midtown Manhattan, a lot of you are from New York, about 60% capacity now with in-person hearings. That's what we're starting to see. It's coming back to some extent, but to all of your points, I don't think it's going to be, it's never going to be back to the way it was pre-pandemic. Richard?
Yeah, so first I should say I don't really have a strong preference. I didn't think it was difficult to evaluate credibility of witnesses remotely. So it really turns on the preferences of the parties. But my experience is that counsel generally prefer in person. They think they can be more effective in cross-examination in particular.
Is there a money factor in there too? They make
There
more
may
money?
be a money factor. I think that
I mean, I hate
the
to
one
be
case
cynical.
I have
I do
now,
hate to be cynical, but it seems like
Yeah.
there might be.
it may be. The one case I have now that's entirely remote is a relatively small case. So the
Yeah.
economics wouldn't work any other way. But also, as everyone else has said, I don't think I've had a single hearing that hasn't had some hybrid component since we came back to in-person hearing. There's always the marginal witness or the very far-flung witness,
Yeah.
or the witness where credibility really doesn't matter. And there are the cases that really turn on documents where, cross-examination isn't really going to advance the ball very much. By and large, it's the strong preference of lawyers to be in person.
Sure. No, I've noticed that too. And the arbitrators, like you said, it doesn't really matter. But a lot of arbitrators, when we were coming out of pandemic, they went to their vacation homes and during the pandemic, and they liked staying there and they wanted to kind of stay there. But we tell the AAA ICDR arbitrators, I know the other institutions do this too, if you want to stay remote completely, you got to put that on your resume that goes out to the client. They have to know initially up front. And we do have a few AAA ICDR arbitrators that only go remote now. I'm not sure if you guys knew that. So we did.
Really?
David, how's?
Yeah, I would say that as it relates to mediations, they are 90% remote. And I think that's in part because typically you schedule one day. So if any of the parties or counsel are traveling distances or live far away, then it just doesn't make sense. So I think in terms of savings and the fact that I think mediation works perfectly well via Zoom, those tend to be, I think, presumptively remote. I think the arbitrations I'm finding are presumptively in person now, unless, of course, it's just so inconvenient for too many people. And I had two examples of two cases a month ago. One, it was from the beginning assumed it would be remote, but it was a big case with lots of documents, and the panel tried to kind of nudge them to see if they would do it in person. And one side said, we're all in Minneapolis, we're all in Minnesota, and we have others who would have to fly in from elsewhere. So they stuck with wanting it
Yeah.
remote. So we said, okay, it'll be remote. I had another one last month. It was a hearing where we had one of those enormous rainstorms. And so of the day of the hearing, they were saying, don't drive, et cetera, et cetera. So we, at the last minute, it was supposed to be in person. We changed it to remote for that day. And then the next day, you know, the sun was out, it was perfectly fine. So he said, let's go back to in person. And then one of the counselors saying, no, it's going to be so difficult to come in. It's a long drive, the weather, the trains, the this. I said, where do you live? He said, Bayside, Queens. So I said, you'll come in. So we got together for the remainder of the hearing.
That's great. We have a comment in the audience, I mean, virtual audience. Our experience is that cross-examination in person is much more effective in person than remote. Do you guys agree with that? No comment?
I just know lawyers feel that way.
Yeah.
I don't,
Okay.
as an arbitrator, I think you can be just as effective. Where I think lawyers are really, during the lockdown, where lawyers were really disadvantaged was in preparing their own witnesses.
Yeah.
Particularly if the witnesses came from a different culture and didn't have any experience testifying, and you're trying to prepare a witness who doesn't really understand the process remotely because everyone is stuck at home. That was really a hardship, I thought.
Sure.
Counsel.
Jeff,
Another comment. Yes, Steve, I'm sorry.
To add to that,
Yep.
I think when you have a difficult witness who's not responsive, it's much easier to bob and weave on when you're 100 miles away or hundreds of miles away. When a good litigator will know how to take control of a room when cross-examining a witness. Probably can do it on Zoom too, but it is harder. And so it's better for the arbitrators, I think, to have a more effective cross-examination.
Sure. Another comment, I find that in-person mediations are considerably more effective when the parties are relatively unsophisticated and or have not been through the litigation process much or at all. Okay, so.
I agree.
You agree? Okay.
I agree.
Okay, so now comment?
I was just going to ask Ms. Lupo can explain, you seem to suggest that once you counsel parties that they would maybe select to have a mediation in person. And I'm wondering what the reasons you would give.
That was one of the reasons, right? So in my pre-mediation work, I'm always sussing out whether or not the sophistication level of the party. And I don't make an assumption when it's a B2B or a commercial matter that there is the level of sophistication that that party needs to be in a mediation process. They may be very sophisticated in regard of their business, but this is a different process. So I ask counsel and I do pre-mediation work with the party. And if I see that this party would do better in an environment where we're all in person together, then I would suggest it. If I see that the party would be just fine without it, that's fine too. But I do make sure that folks understand that there is a difference. I'm not going to say that there isn't, and I don't think anybody on this panel would either, or any of you who practice and have done remote and in person, that there isn't a difference, that there isn't an energy that's missing. And mediation does work off of energy. So that's what I would, how I would respond to your question.
Can we have another virtual comment on cross-examination? There's no reason for it to be different. Cross is cross. The only issue is attorney under the table interference.
Oh, yeah.
Okay, so.
Oh, yeah.
Interesting comment. Okay, so before we move on to the next topic, I have to do the CLE letter, okay? And the first one is A. A for Apple, A for American. First letter is A, okay? Okay, we're going to move on to Richard and David, a clash of duties. The arbitrator's obligation as arbitrator to maintain the confidentiality of the proceedings and as attorney to report attorney misconduct. Wait, yes. Signing in and signing out. That's all you have to do. But the virtual world, you need to have that letter. And again, it was letter A. Okay. Yep.
There was no sign-in. When I got here. Oh, there was no
Right when you walked in the door. The person is not here.
Yeah, it'll be there when you leave. Yeah. She had to step away for a minute, but she'll be there when you leave. Okay. All right. Richard and David, take it away.
Okay.
So when David suggested this topic, it really resonated with me because when I was a baby arbitrator, I had exactly the situation that that gives rise to this clash of duties, or it seems so. So, and I'll start with the hypothetical. You have a two-partner plaintiff's personal injury law firm breaking up. The partner, who's the claimant, who had no control over the books and records, did not run the finances at all, did not have access to the financial records. At the preliminary conference, didn't appear in the pleadings, but in the preliminary conference accused the respondent of having diverted client funds, settlement funds, proceeds from judgments and so forth, to his own personal use. So, and I recall seeing my career as an arbitrator passing before my eyes, fledgling as it was, because I'd been on the City Bar Ethics, Professional Judicial Ethics Committee, and I knew that one of the strongest duties to disclose misconduct is if you know that an attorney has been stealing client funds, misusing them. And that presented the issue. Okay, do I want to keep my license to practice law, or do I want to be a confidential arbitrator? And there are ways to deal with it. That I dodged that bullet because I had discovery done immediately, an inspection of books and records, and I invited the claimant to amend the pleading, and we'd have a hearing on that issue if there was evidence of such conduct. And I knew that if I was finding that there was such conduct, I would have an obligation to report. And it turns out after the inspection of the books and records, the allegation was withdrawn. So deep sigh of relief. But it doesn't necessarily go that way. You can actually be confronted with the kind of attorney misconduct that triggers your obligation as an attorney under Rule 8.3 to disclose, to report that conduct to the appropriate authorities. So Rule 8.3 of our ethics rules, and based on the model rules, starts with this sentence: a lawyer who knows that another lawyer has committed a violation of the rules of professional conduct that raises a substantial question as to that lawyer's honesty, trustworthiness, or fitness as a lawyer shall report such knowledge to a tribunal or other authority empowered to investigate or act upon such violation. So it's not any misconduct, it's conduct that goes to this nature. There's an exception for in 8.3c that says this rule does not require disclosure of information otherwise protected by Rule 1.6. You go to 1.6, confidentiality of information. That exception really only applies to information obtained in the course of representing your client. So since a neutral, and what I'm saying here really applies as well to mediators as arbitrators, since a neutral doesn't have a client in the fight, that exception doesn't apply. And this is a rule that is stated in absolute terms. And I'll let David talk about the countervailing rule.
Well, this is Richard is citing the rules that apply to attorneys, and now we'll move to the arbitrator's duties of confidentiality. So AAA Commercial Arbitration Rule 45 states, subsection A, that unless otherwise required by applicable law, court order, or the parties' agreement, the AAA and the arbitrator shall keep confidential all matters relating to the arbitration or the award. So quite broad. And then there's the ABA AAA Code of Ethics for arbitrators. And there's Canon 6 that speaks to that an arbitrator should be faithful to the relationship of trust and confidentiality inherent in that office. And then in subsection B, it states the arbitrator should keep confidential all matters relating to the arbitration proceedings and decision. So consistent with each other. So those are the obligations of confidentiality for an arbitrator. The duties to report is not in the arbitrator rules of ethics or the rules of a provider. That's really for an attorney. So if you're an arbitrator but not an attorney, you're not dealing with these type of issues and these conflicts. There's no conflict for an arbitrator who's not an attorney, but the conflict exists for arbitrators who also are attorneys. And so there's the rub, and that is most of us, if not all of us. So let's see if there's any cases, any opinions, anything in the United States of America that speaks to this issue.
Let's start with New York. We did our research and were unable to come up with any case, any ethics opinion, any disciplinary proceeding involving the application of Rule 8.3 to an arbitrator or a mediator in New York. But there are a few cases around the country, and you'll be happy to know that they're very different on their facts, and there are literally 3 cases we know of, and each one came to a different conclusion. So the first one, I'll start off with the Illinois case. The Illinois Bar Association advisory opinion on professional conduct came to the conclusion in a case involving a mediator and the application of the mediator's obligations under the Illinois Uniform Mediation Act and the Not-for-Profit Dispute Resolution Center Act, which I'm not familiar with, but it was basically a statutory analysis, that the duty to report that an attorney has is absolute and overrides the duty of confidentiality of a mediator. Very, very clear language. It's absolute. That's what was the Illinois. Now, it was not based on general principles. It was based on these statutes as the countervailing principle. I would think that the statutes might be more forceful as a countervailing force than general principles. And yet the committee was not persuaded. Now, in order for this to apply, it has to be, as we talked about before, specific types of conduct, misconduct, under Rule 8.3. Now, in this particular case, the conduct was under Rule 8.4C, which prohibits lawyers from engaging in conduct involving dishonesty, fraud, deceit, or misrepresentation. Unfortunately, or fortunately for the parties at least, the opinion does not get into the gory details of what the conduct was, so I can't really shed any light on that. But it certainly involved dishonesty as the nature of the misconduct, and it was a pretty hard and fast rule in Illinois, anyway. David, what?
Okay, so let's see what else there is out there. So there's a Pennsylvania Bar Association Committee on Legal Ethics and Professional Responsibility informal opinion going back to 1992. So the question had to do with a fee dispute, and the committee was asked whether or not, as a member of an arbitration panel, may award a fee to a lawyer who has neglected to have the fee agreement with his client reduced to writing. And also asked, the question more pertinent here, whether or not you are obligated to report to the disciplinary board the fact that the attorney did not comply with Rule 1.5b. So 1.5b of the Rules of Professional Conduct in Pennsylvania says that when a lawyer has not regularly represented the client, the basis or rate of the fee shall be communicated to the client in writing before or within a reasonable time after commencing the representation. So that was the question that was presented to this ethics committee, and the view was that there was no duty to report such conduct unless you determine that the lawyer's failure to comply with Rule 1.5b raises a substantial question as to the lawyer's honesty and trustworthiness or fitness as a lawyer in other respects. So that's really picking up, I think, on the language of Rule 8.3 that Richard mentioned before, that raises a substantial question as to the lawyer's honesty, trustworthiness, or fitness as a lawyer. So here, with regard to signing an engagement letter that sets forth the fees, that was a factual determination, and they felt ill-equipped to actually express an opinion on the factual issues of that case. So it depends on how serious it is and whether the wrongdoing, if it rises to the level of wrongdoing at all, implicates honesty and trustworthiness and fitness as a lawyer. So again, this was an advisory opinion, not binding on the disciplinary board or the Pennsylvania courts. So then we have another matter. Now we're going to go to Tennessee, where we have a Board of Professional Responsibility of the Supreme Court of Tennessee in a matter involving a fee dispute mechanism that was in existence. Sounds similar to what we have here locally. So the committees are designed, these arbitration committees are designed through settlement or arbitration to resolve disputes between clients and attorneys concerning fees for legal services. And it provides a function that's very beneficial to save cost and avoid having to go to court and so on. So here, there must have been some wrongdoing that was alleged, that was found to be the case, or at least alleged. And the board said that it recognizes that in some instances, attorneys may be reluctant to participate in the peer arbitration process due to the mandatory reporting of ethical misconduct provisions of Disciplinary Rule 1103 of the Code of Professional Responsibility in Tennessee. Therefore, in order to encourage greater participation and cooperation in the fee arbitration process, panel members are excused from the ethical requirements to report ethical misconduct during the course of service as a panel member. So here is really a policy matter in order to encourage people to serve as arbitrators in this context, and I suppose to encourage attorneys to access the process. They have found an exception to the obligation to report. So basically, we have three little samplings, one in Illinois, where the determination was the duty to report lawyer misconduct is absolute and overrides the obligation of confidentiality imposed by a lawyer acting as, in that case, it was actually as a mediator, but I think the same would apply to arbitrator. Pennsylvania hedges a bit, saying it depends upon the specific facts of the case, that if it doesn't rise to the level of implicating the trustworthiness and honesty and ability to function as a lawyer. And then you have the Tennessee example, where there was an exception to the rule or obligation to report misconduct as a matter of policy in order to not discourage arbitrators from accepting those appointments. So, I'm wondering, because it's, this is a smattering of sampling, whether in the unlikely event anyone here in the room or on the Zoom has encountered cases or circumstances where this tension or conflict has arisen. Anybody?
Well, I know, Rich, you did with the Donald Trump case, and I can mention that because it went public, but it was pro se, wasn't it?
Yes, yes. I would
back in 2016 campaign.
2016, and I can talk about it because it was well publicized on MSNBC and CNN, and I enjoyed the fact that.
But not Fox.
No, not Fox. But no, I can state affirmatively that I actually ruled in favor of the 2016 Trump campaign against a former employee of the 2016 campaign who was threatening to disclose what were really gossipy type things, not so much campaign strategies, but things that were going on in terms of affairs between various prominent people who were active in the campaign. And there was there was a desire on the part of the Trump campaign to muzzle, I know that this comes as a big surprise, to muzzle a former campaign worker from making any such disclosures, and came in to get a preliminary injunction from an emergency arbitrator, which I became upon Jeff's call out to me. And what I came up with was a 17-page opinion at 4 o'clock in the morning that was brought to the clerk's office just in time to head off a public filing of these disclosures. The clerk did in fact honor the decision that I made, which is that if there is any such filing, it should be filed under seal. The judge, when it came before her, and she'll not be identified, came before her at 10 a.m., said, "What is this?" And said, "We have sunshine laws in this state. You know, we're not sealing anything." And of course, then my wife called me and said, "Go to the nearest television and you'll see that you're being ripped for having been party to," I think it was called, Jeff, a Star Chamber proceeding.
Star Chamber, yep.
Yeah,
Yep.
yeah. But I have a question of Rich.
Did that involve arbitrator reporting of misconduct versus maintaining confidentiality?
I would ask you the following.
Okay.
I would ask you the
Because it
following.
was pro se.
Suppose it does not involve attorney misconduct. Suppose you're dealing with Rule 45 of the AAA commercial rules, which says that the arbitrator has to keep things confidential. And suppose the arbitrator determines or has suspicions in the course of taking evidence in a case that a party is creating a public nuisance or danger. So one of our colleagues who's not here today, but has in similar circumstances related this story probably 100 times about a bridge in Vermont, which he struggled with because the evidence in the case was that the bridge was made with subpar materials and created a safety hazard for people. And he wanted to know whether he had the duty to disclose to a public authority, regulatory authority, what had been learned in the arbitration. So how do you deal with that? I'm shaking heads, but I'm not sure.
I think I remember that anecdote being described, and that person, I think, did report it because there was a risk to people's safety and perhaps their lives.
Well,
And,
you happen to have someone who sat as a mediator in a very similar fact pattern. So I sat as a mediator in 2015, and during the course of the mediation, it was disclosed that one of the parties had misrepresented their vocation. And their vocation was such that public safety would be at issue. And in my retainer agreement as a mediator, I have a carve out for criminal, threats to the speaker's well-being, third parties, threats to me. Those things I'm going to disclose. So weirdly enough, I activated that clause and I reported that which I learned, as did the two lawyers, because the party's lawyer did not know. And it was the opposing party who had dug up the information and found out that the counterparty was not, in fact, who he had said he was, and that there was a public safety issue. And there was a serious public safety issue.
I have a question for you. That's fascinating because you actually have a carve out from your confidentiality agreement within your retainer agreement,
You're
right?
going to ask me why and how did I come to that?
Yeah.
So in addition to doing commercial business to business, I do high net worth divorce. So in divorce, once in a while, people will threaten one another. And when that happens, I need to be able to act. And that's how I came to that. I spoke to divorce lawyers and criminal lawyers, and I said, what do you folks do? right? What do? We have these canon of ethics. We have, all of these things that happen in our proceedings or in our meetings or in a four-way, in a divorce negotiation or in a mediation or what do you do? And then I made that carry over into all of my mediations. And I just left that in there. And I make sure it's italicized. If you don't read it, that's your problem, because you're also affirming that you have read everything in my retainer agreement. But yeah, that's the one time that I have had to, and it was a serious public safety issue.
Interesting. We have a comment from the virtual audience about Richard and David's talk. Wait, hold on. I think it happens reasonably frequently, and people go to ethics authorities for counsel. Okay, and then another comment, Rule 45 also includes something of a carve-out that may apply to public safety requiring confidentiality unless otherwise required by applicable law. Okay.
Mark has a question.
Yes, Mark.
In relationship to your carve-out, if it doesn't involve public safety, but it involves criminal activity or allegations of criminal activity.
So
For example, in mediation, business
Yeah, I know where you're going.
Family business,
Mm-hmm.
mediations and arbitrations, there's always not always, but a
Mhm.
lot of times evidence of tax.
Mm-hmm.
And, that's.
Tax fraud.
Oh, yeah.
Oh, yeah.
And, I arbitrated a case between, brothers who, they had an arbitration clause in their corporate stock agreement. And, the whole case was about tax fraud,
So again, we go back to tax fraud. Should we? Probably. Do we? Unlikely. You're threatening to kill your brother. Oh,
Yeah.
that's where we're going. You're threatening to kill me. Oh, I'm clearly going to, sound an alarm. You're going to threaten Rich and Rich
Well, not-
Rich
not
and
so much,
Richard.
yeah.
Well, Richard,
you think about
that's the level that I am uncomfortable as an attorney mediator, an attorney arbitrator. If a lawyer or a party makes that level of threat, I'm uncomfortable at that point to keep that confidence. I don't know if other people would feel differently, but if somebody was killed, I would not be able to live with myself.
Steve, you have a comment?
I have
or
a comment
question?
on this, returning back to arbitration.
Mhm.
In arbitration, you do have an outlet, because if there's tax fraud or other
Oh, yeah.
activity among the parties, you write your award and then it becomes public when the award is out. David and I sat on a case with this self-storage business. We put a lot of that stuff in the award. In fact, we said that in order for one to collect against the other, if they were two general partners, they had to notify the limited partners of their criminal conduct. And there was another case I had recently where the parties have been fighting for years. It was a second arbitration. The first one didn't finally resolve stuff. They brought everything back to us. We issued a 100-page award detailing all of the shenanigans. And we got a letter thanking us, saying that they now settled the case and to remind us to keep it confidential. So the award can have that effect.
It's great.
Okay, before we move on to the next section, first of all, I have to give the next letter for CLE for the people in the virtual world. It is D for David, okay? D for door,
Thank you.
okay? D, okay? So the first one was A, the second one's D, okay?
Don't assume what the first and third letters are going to be.
Mhm.
Okay. Actually, before I go to the last, to Rich and Jen for the last topic, just I'm going to go through everyone quickly, just on AI. AI is becoming a hot topic. AAA is talking a lot about AI. Our president is presented on it quite frequently. Just want to know what your thoughts are quickly on AI, where it's going. Do you see some problems with it in the arbitration world? Steve, I'll start with you again. Sorry.
Okay, so AI has been around for a long time.
Yep.
What people are talking about are generative AI. And that is moving so fast that whatever I say about it, it'll be obsolete on tomorrow. We just so everybody puts on their calendar, the week of November 18th is New York Arbitration Week, and we are going to have, it's not official yet, but we are talking about having like a roundtable discussion led by Bridget on use of AI in business and what people are doing, what they're seeing, and how it might affect arbitration and other dispute resolution. So stay tuned. I mean, right now it's it's a tool. If you try to use it to write a brief or something, it's not anywhere near there yet.
Yeah.
But it does help speed up research. I mean, I do a lot of research and writing, and doing Westlaw, Ask Westlaw is just a really interesting tool because you keep having a conversation with it and learning how to write prompts. I think we all have to learn to write prompts. The line that's been going around is that AI will not replace lawyers, or arbitrators, but arbitrators who don't and lawyers who don't use AI will be replaced by those who do.
Good point. Good point. Dana?
Well, I agree that generative AI is advancing so quickly that what we say here, may be dated tomorrow. Look forward to the New York Arbitration Week event on this topic. But one thing that may be useful to the arbitration community is, how-tos on how best to optimize the use of generative AI rather than I think it's also healthy to learn about its dangers and limitations and what to be wary of, but also more constructively, like how do you use it? I teach students that are, much younger than me, and they're using it, right? And there's all these limitations in schools on what's permissible and what's not permissible, but the world is, moving so quickly, and the next gen is using it, whether we're using it and learning about it or not. So I think that, we all need to learn how to use it and how it's being used as much as its dangers.
Yep. Rich?
So I'm going to return to the mundane and point out a caution that arose during a case that I had on Zoom. It was a fairly large case. There were 20 Zoom boxes for each of the participants. And as I was going around the Zoom room, I saw one box that was not filled with an image of a person. And that was not unusual in and of itself. Some people turn off their video and, it could be just a name there. But the name that I saw was something assistant. Initials and then the word assistant. So I said, can so-and-so assistant please identify themselves? No answer. Of course, I was talking to an AI, a bot. I was talking to a bot. Serves me right, asking for identification. And I then turned to the other parties, and no one owned up to the fact that one of them had trained this bot to answer every single Zoom invitation by participating in that session and then producing a transcript of everything that had been said by everybody in the meeting. So I terminated the session, identified the person who had done this, told him that that's never to happen again. And then about a year later, more recently, the same thing happened in another case, but this time I knew what had happened because I had the other experience. So I would just caution you when you're doing hearings that are not in person, this is now becoming somewhat common, where people say, I just have to turn on a switch and I can get a transcript of in-person meetings, Zoom meetings, what have you, to aid me in my business or my personal life. So just be on the watch for it.
Absolutely.
If you,
Because any of those 30 participants were in a two-party consent state.
Oh, yeah.
Correct.
Correct.
Yep.
Yeah.
There we go. I knew this would tie in,
Because it's in the
Sherman.
Tying everything
retainer
in,
agreement,
Sherman. Thank you.
Sherman. It's in the retainer agreement.
Yeah.
Jen, your thoughts?
yeah,
Yeah, couple of things. I too teach like Dana does, and I was teaching I was writing my final exam when ChatGPT launched in that fateful November. And there was a flurry of, what do we do? What do we do? What do we do? And I said, what do we do? We deal with it. And this is what I would say to all of you that are in the room and that are in the ether. You have to learn. As complicated as it may seem to you, you have to learn how to utilize generative AI. You just do. 2, do not put any of the materials for any mediation or arbitration into any generative AI program. It is an open loop.
An open
It is
loop.
taking all of that information to teach itself. You have now breached confidentiality. So do not utilize it to do that. What I do use AI for, and I do, is to start generating outlines and questions. I have a panel coming up. We're going to be up in Albany next
Albany,
month.
yeah.
So we're going to be in Albany next month. Host Mary's here, her committee. I'm going to be moderating a panel. I started putting together, using AI, what's the outline for our talk. So that's what I'm utilizing it for. And what I'm noticing is that I will then take the outline I have and then I have to reality test it against the Googles, the Westlaws, the Lexuses, to make sure that the information I'm getting is kosher. Because we all know what happened to the lawyer in the Southern District for utilizing AI and relying upon the cases that were spit out that were non-cases. So I am a caution and I'm also an encouragement.
Good point.
So I'd like to just pick up on that point about the case we all know about. Some judges appear to be adopting an approach that requires lawyers to disclose if they're using AI in their submissions. I don't understand the need for that, because I see at that level, we're not talking about sophisticated AI, generative AI issues, but at that level of brief writing and doing research and drafting a brief and citing cases, a lawyer has the same obligations whether she's using, AI or she's using Westlaw, right?
Or a junior associate.
Right.
Yeah.
Or junior associate. I mean, you need to read the cases that you're citing, so that's your obligation, and I think arbitrators need to make the point subtly, but make the point, convey the notion to counsel that you're going to be reading what they submit to you, right? They're not going to give you a string cite without your reading those cases. So I don't see the need for a special rule of this kind with respect to AI. You have the same obligations you have. You have your obligation of candor, and I don't see this as a separate category or a new obligation or requiring a new procedure.
Excellent point. David?
Well, the only thing I'll add is that I haven't heard, now being the last person, and nor have I thought of a way that using AI would materially benefit me as an arbitrator. And I certainly wouldn't use it to generate a draft award. And the things that are most time consuming, thankfully, require judgment and to me cannot be replaced with AI. So I think that the practitioners have much more to be concerned about and maybe to utilize it, though I really don't know. You hear about the unreliability of it and the hallucinating, and then the concerns about disclosure that was referred to before. So I'm kind of waiting cautiously to see whether that will impact or help me as an arbitrator, but so far I haven't seen that that's the case.
You shall see. One comment from the audience, virtual audience, I specifically put into my scheduling orders that AI is not allowed, just the same as any recordings, screenshots, et cetera, are not allowed. Okay, so we're going to, two quick comments because we don't want to run this at our time. Yep.
Just before I left here, I got an email from case text. And they have something that's AI case text or case text AI, your new associate. About 7 different categories of things.
Interesting.
Free trial.
And so I want to reinforce the point Jennifer made, which is, so if you put confidential information in, the system's going to remember it, and that's a sort of tree falling in the forest, as anybody here, but there's a specific allegation in the New York Times' case against OpenAI that by using the right prompts, the New York Times was able to recreate word for word articles that OpenAI had read. Think about if that happens in a.
Interesting.
Absolutely, or an arbitration, absolutely.
Very interesting. Okay, we're at our last segment now with Rich and Jen are going to close it out. Tricky issues involving pre-awarded interest, attorney's fees, in-camera reviews, and non-party subpoenas.
Now we're going to do all that in 20 minutes.
20 minutes,
We got it.
exactly.
We got this. Come on.
All right, this is the audience participation part of the program. What we're going to do is we're going to take these 4 topics, we're going to split them between ourselves, 2 and 2. And we're going to give you a hypothetical with regard to each. We're going to ask you, those people who are in the room anyway, to vote as what decision you would make under these circumstances. We're then going to ask one of you, and I have friends in the room, so I'll be picking on people if they don't volunteer, to give your perspective on why you voted one way or the other. Okay? So Jen, you want to lead us off?
So I'm starting off with the awards of attorney's fees and associated legal expenses. Hypothetical. You are presented by the prevailing party with an application for an award of attorney's fees. The party's contract is governed by New York law and is silent on the recovery of attorney's fees. The AAA's commercial arbitration rules apply. The prevailing party argues that New York law allows for the recovery of attorney's fees where the adverse party did not assert a claim or defense in good faith, and that in the case before you, all of the adverse party's defenses were wholly without merit. You are not persuaded by the prevailing party's argument, but you are aware that both parties sought attorney's fees in the addendum clauses of their initial arbitral pleadings, which under AAA Rule 49D2 confers discretion upon the arbitrator to award attorney's fees to the prevailing party. But the prevailing party did not argue that as a basis for its requested fee award. First question, should you grant the application for attorney's fees under the authority conferred upon you by AAA Commercial Rule 49D2, even though the prevailing party did not cite the authority in support of its application? Or, number 2, deny the application for attorney's fees on the ground that it would be inappropriate for you to grant relief based upon an argument that was not made by the prevailing party?
Okay, so who in the room would grant the application for attorney's fees notwithstanding that it was not argued? All right. And who would not grant attorney's fees?
For the virtual world, the majority goes with the second question.
And here too, within the room, it looks like.
Correct.
So,
No, I was telling you I was telling the virtual world about the room.
oh, I see.
I can't tell.
You can't tell what the virtual, I mean.
My eyes are not that good.
Shocking. Okay. So for those of you who voted that you would not award, what about the fact that it's right in the rules?
Absolutely.
And that the rules confer upon you as arbitrator the authority to grant in 3 circumstances, and one of those circumstances is present. Do you ignore that?
It's discretion, right? It's not.
Correct. It's
Thou shalt grant.
Correct.
So
I've
you have
always-
to evaluate the totality of the circumstances.
But they asked for as a sanction as well. That they did brief, and you are entitled under New York law to do
Well,
that. For
they're
bad
asking
conduct.
for,
They're saying bad faith, right?
they're arguing that all of the defenses, they didn't say bad faith per se, but they said that the defenses were, well, bad faith, were wholly without merit, so bad faith. But here's the 3 things, right? First, be specific. For those of you who are attorneys and arbitrators or are counsel in arbitration, be specific in your drafting of your arbitration clauses. That's the first place to start. The second one is state law. So we did a little survey of state law. So the California Arbitration Act grants the arbitrators discretion to award. So we would go back to the demand for arbitration, and the demand for arbitration asked for attorney's fees. So we have a demand for arbitration, which is part of the record. And we also have discretion under 49D2. So we could grant that application despite the fact that the movant did not ask for that relief. Other states that also speak to granting arbitrators the discretion to fashion this remedy is also, you have Article 75 of the New York CPLR. Texas Civil Practice and Remedies Code, it's Chapter 171. They also allow for arbitrators to have this discretion. And then lastly, Florida, Chapter 682 of the Florida statutes also governs, and it allows for the arbitrator to have this discretion even when there isn't an underlying statutory authority to grant attorney's fees. But the basic fact here, and I think that, Rich and I gave you a little bit of a little confusion, is it's before you. You were asked for this relief in the first instance with the first paper. The demand for arbitration and statement of claim, and in the answer. So, Rich, why don't you take off? Any questions? Go ahead.
Yes.
Would it be advisable for the arbitrator to raise the issue before you begin the hearing?
Of attorney's fees? You could. I mean, it is in the case file before you, so you could. I know of arbitrators that will ask for fee applications before they close the hearing, as opposed to issuing an interim award and then asking for a fee application for economy's sake, depending on the size of the claim. So yeah, you could.
All right, moving on,
Wait.
because we have very little time. We are now going to jump to a different issue, which
Go to something
is
fun.
privilege reviews. Short hypothetical, but listen carefully, please, to the options. The parties have challenged the privilege designations of documents that appear on their respective privilege logs on the grounds that the challenged documents are not immune from disclosure under either the attorney-client privilege or the work product doctrine. There are 200 documents in dispute. Should you, 1, request that the parties submit the documents to you for in-camera review? 2, request that the parties submit the documents to you for in-camera review, but only after they have agreed to stipulate to allow you to perform that in-camera review. 3, request that the parties submit to you for in-camera review only those apparently significant documents for which the party challenging the privilege assertion has made a showing to support a good faith belief that an in-camera review would show that the documents were not privileged. D, ask the AAA to appoint a privilege arbitrator to review the documents in camera and determine whether they are privileged. And E, none of the above. Now, if anybody can remember all 5 of those options, you'll get a medal.
You need
I
the sum of
remember
the
none of the
above
above.
too.
Usher?
Number the third.
Going to take a vote?
The definitive answer for this question is it depends. I think, horses for courses, it depends on a lot of other factors in the case. Obviously, in-camera review, if I'm the sole arbitrator, I'm the only one that really matters on seeing the documents anyway. So I can imagine a circumstance where I would go back to the AAA and ask for somebody else to review the documents. I can also imagine the situation where, it seems like a very overblown privilege list, and I kick out certain documents that I say, these probably need review. So sorry, can't do anything.
Yes, Fred.
This exact thing happened to me a few months ago, last year. And I said, I wanted to go to a third party. Where there that many documents beyond, I'm like, I don't want, if they're privileged, But it was actually, they were pending power. I don't want to see them, I want someone else to decide. And the party's like, no, we want you to review. Like, really? And it was a really bad idea. Because it gave me a really negative impression. So I would say, like, and I was a sole arbitrator, so, it's the kind of thing, like, you can't forget red. Try to say, like, well, the fact that this guy is like a real jerk didn't influence the rest of the case, but so I would say the practitioners, if you slow things down to the thing, I wouldn't want the person who's deciding the case to be seen in front of the conflict.
And that,
The city bar did a report on this last fall,
Mhm.
and they did another spin on it, which was, if the parties want you to do it, and even if you try to talk about it, maybe you should do it. But if you're uncomfortable or they're uncomfortable, they can't put another option, not a privileged arbitrator, because nobody's appointed that person as an arbitrator, but a privileged expert who then write a report saying.
it's another possibility.
Mhm.
I mean, that's what I suggested, wasn't a privileged arbitrator. Like
Like a special master.
Referee, right.
But
Referee.
there is no right or wrong answer here on any of these questions. But I think that what I would do is to ask the parties, because the last thing you want to have happen is what happened to Fred. You don't want there to be a situation in which you've seen the documents. Some of them turn out to be privileged, but you've seen them. And a party could then say, well, I'm going to vacate the award on the basis that he considered evidence that turned out not to be admissible. So you want to ask the parties to stipulate for your protection, but you also, more generally, it's the parties' process. You want to ask them, do you want to go with a privileged arbitrator or an expert, or do you want me to look at them, in which case you both have to stipulate?
I don't see the need for stipulation. If you give the parties the option and they say, go ahead, we have no objection. And that's,
Well, that is a
you make a
stipulation,
record of
in
it.
effect.
Right.
But
I would put it in my
not a
award.
formal stipulation needed.
And
I think sometimes it depends on whether the case is large enough to support bringing someone else in, right? I think, but you really leave it to the parties in the end.
Agreed.
Right?
Mhm.
All right, we're going to move on to the next topic. We're going to do.
Can I just note
Oh,
that,
I'm
like,
sorry.
in the context of ESI and using search terms to do document discovery and collection, sometimes the privilege issue comes up kind of like in the back end,
Right.
because there's been a document dump based on search terms, and then it's harder for the tribunal to avoid hearing about the content, even if they don't see the document or they, so that's generative AI may play a role in that someday too.
Okay, we're going to do subpoenas now.
All right, so subpoenas, otherwise known as summonses, under Section 7 of the FAA. So here's your hypothetical. You are presented by the parties with a joint request to issue a summons for testimony and the production of documents by a third party. You believe the proposed summons is likely to be unenforceable under the FAA or any state law because it purports to call for the production of documents before the evidentiary hearing and to require the witness to appear at a hearing location that is more than 100 miles from his home. Should you issue the summons? B, alert the parties to the fact that the summons is likely to be unenforceable, but nonetheless issue the summons. C, decline to issue the summons, but offer to sign a letter requesting that the non-party provide the requested testimony and documents. D, decline to issue the summons. Show of hands, who would issue the summons?
Depends on the situation. I would have
That's the
either or
situation.
E. Have done both.
Okay, go ahead. So that's two that would. Who would alert the parties that the summons is likely to be unenforceable, but nonetheless issue the summons? Okay. Decline to issue the summons and offer a letter. Okay. And D, decline to issue the summons. Okay,
There's another option.
go ahead.
the Goldstein rule.
Mark Goldstein written about this on his blog in very enlightened way, which is you can move the location of the hearing.
You didn't let me get, you're putting the cart before the horse, my friends. Just wait for it. This is tantalizing information. Okay, so you can issue the summons, and then you physically, if it's a tribunal of 3, all you have to have is, you don't have to have the whole tribunal, you have to just have a majority of the tribunal. So part of the tribunal goes off to the location where the witness is located. And you have the hearing, the pre-hearing hearing, couldn't come up with a better word for that, right? In that location. So you would do it within the 100-mile radius of that witness, and that witness will bring the documents with them there. Oftentimes, if it's a friendly witness, the witness will just provide the documents. But if it's an unfriendly witness, that is a way around it, is to you physically going, to you being the arbitrators, physically going to the locale of where this witness is located. Mark, I see something on your face. Or is that just a smile? Mark, Mark. Yeah.
You're not used to
Or is that just a smile?
Mark's always smiling.
Yeah. Nobody wants the paper, but they all want the subpoena. They don't understand. They just don't get it.
Okay, I'll go to California and we'll sit there and we'll have a hearing, hearing, and the witness will produce that.
Right. So exactly. But that's the answer, is to turn up. Go ahead, David.
We talk about a pre-hearing hearing. Is it not day 1 of the evidentiary hearing?
Exactly.
So
Right.
that's
Just been moved up?
We need to move on.
We need to move.
I'm
We'll
getting
get
the
there.
hook.
That question.
Go ahead.
All right, so I just need to
minutes.
make a plug for the New York City Bar Association report on the model summons in
Yes,
arbitration,
it's
which
very
has
good.
just been updated with more recent legal developments of the last couple of years, which is now posted on the New York City website. Okay, really
It's
fast.
light reading.
You are presented by the prevailing party with an application for an award of pre-award interest upon a recovery of 10 million. The party's contract is governed by New York law. The AAA's commercial arbitration rules apply. The prevailing party argues that pre-award interest should be calculated at the New York statutory rate under the CPLR of 9%. The adverse party assumes that the 9% statutory rate applies and therefore does not challenge the calculation of pre-award interest at 9%. You, however, are aware that AAA Commercial Rule 49D1 provides that the arbitrator can award interest at such rate and from such date as the arbitrator deems appropriate. Should you grant pre-award interest at 9% on the basis that the prevailing party requested that interest calculated at 9% and the adverse party did not challenge? B, grant pre-award interest at a rate lower than 9% on the ground that 9% greatly exceeds the market rate of interest in effect between the time the claim accrued and the time of the award. Or C, grant no pre-award interest because it was a very close case and awarding interest would constitute a windfall for the prevailing party.
Depends.
Who would grant 9% because the other party didn't challenge it? All right, who would grant pre-award interest at a rate other than 9%, presumably lower? A few. Who would grant no interest? Okay. Very good. There's total discretion under the commercial rules. But again, this raises the same issue that arose in the attorney's fees context. Are you giving the benefit to a party that really hasn't made the argument and thought that 9% was right and wasn't aware that they could argue for either a lower rate, perhaps a Federal Reserve rate, or no award at all? So that is the conundrum.
Well, the takeaway should be, right, the takeaway should always be that oftentimes folks who have a choice of law clause in their contract assume that it is both substantive law as well as procedural law. So 9% interest, it's a New York law. No, it's just substantive law.
And by the way, just to close it out on that point, there's also a New York City Bar Association very helpful report on this issue. And one of the things that the report pointed out is that the CPLR provides for 9% interest in an action.
Correct.
An arbitration is not an action, it's a proceeding. So the report underscores the fact that the CPLR may not be relevant in arbitration at all as to the interest factor.
May I?
Yes.
Just a footnote.
Real fast.
There, in the report, there's also a discussion of two appellate division cases, which give discretion. The argument having been made that 9% was obligatory because there is case law elsewhere that says that the rate in New York should be considered substantive law. So the logic for the arbitrator is, it says the contract is governed by substantive New York law. I'm bound by the 9% because there's this case that says that that the 9% rate is substantive New York law. And there are these two cases, one from the first department and the other from the third department, I believe, which say no, no, the arbitrators have discretion because the rate to be applied is a mixed question of law and fact. That's the first department's iteration of it. And the point is that the 9% rate is available, and the report says, you know, you have discretion to apply the 9%, but you have the discretion to look at a number of other factors. And there's some great federal cases that are talked about in this report, which discuss the factors that can be considered or should be considered in determining what rate to apply. It's a very long report. It's a very sophisticated analysis, but basically you can do what you think is right.
Okay, thank you. We're out of time. The last CLE letter is R for Ralph. Okay, R for Ralph for the virtual world. So that is, all the CLE letters are ADR. Okay, ADR. I want to thank Peter Phillips, the New York Law School. I want to thank the virtual audience and also the audience here in person. And obviously this great panel. You guys are great. A big round of applause for the panel. As always, you guys deliver. Please stay seated because I want to get a picture with you guys and with Peter. But thank you, Peter. Thank you, guys.
Everybody, thanks for coming. There is some knock over there if you'd like to hang around.